81 days. That is the whole distance between the night the soldiers came up the steps of a boarding house on H Street and the afternoon a trapdoor dropped out from under a widow's feet in a prison yard in Washington. 81 days from arrest to rope. Her name was Mary Elizabeth Surratt, and on the 7th of July, 1865, she became the first woman the United States government ever executed. Hold that number in your hand for a moment, because everything that follows turns on it. 81 days. Now hold this one against it. 2 years later, in the same city, under the same flag, for the same conspiracy, the government put her son on trial. He had been in the plot. He admitted he had been in the plot. He said so out loud, from a stage, for money. 5 years later. His trial ran for 2 months. The jury heard something close to 300 witness appearances. And on the 10th of August, 1867, the foreman stood up in a hot courtroom and said 7 words. We have not been able to agree. John Harrison Surratt, Jr. walked out of that building and lived another 49 years. He married, he had children, he audited freight bills for a steamship line in Baltimore and drew a salary until he was past 70. He died in 1916, an old man, in his own bed, with his wife beside him. Same conspiracy, same evidence, one rope, one jury. That sentence is the whole documentary, and by the end of it you are going to understand exactly what changed in the 24 months between those two proceedings, and why the change came 9 months too late to save the woman in the black dress. Start with her, on the last day. The 7th of July, 1865, was one of the hottest days of that summer in Washington. The New York Herald reporter who stood in the yard wrote that the sun shone brightly upon the terrible scene, and later, less carefully and more honestly, that the red sun poured its rays with fierce intensity upon the dead and the living. A soldier named William Landon, who was there under orders and wrote about it afterward, remembered a broiling July sun and dense clouds of stifling dust. At exactly 1 o'clock in the afternoon, a heavy door opened from the northwestern hall of the old Arsenal Penitentiary into the courtyard. Mary Surratt came out first. She was wearing black, a black bombazine dress, a black bonnet, a black veil. Bombazine is a cheap mourning fabric, a twill of silk and wool, and she had been in mourning clothes for most of 3 years by then, since her husband died. She was leaning on 2 men. 2 priests walked behind her, Father Jacob Walter and Father Bernardin Wiget, and one of them carried a small cross and a prayer book. The herald man watched her come out and wrote that she looked very pale, that her limbs seemed to fail her, and that what was on her face was more horror than physical fear. Those are 2 different things, and he was right to separate them. Fear is what the body does. Horror is what the mind does when it finally accepts a fact it has been refusing. Behind her came George Atzerodt, then Lewis Powell, then David Harold. There were 4 nooses on the scaffold, and 4 graves already dug beside it, with 4 pine coffins waiting in them. Landon called the coffins wooden overcoats. Soldiers had cut them from gun boxes. Mary Surratt had to be helped up the steps. When she reached the top, they seated her at the right-hand end of the platform, which in the grim etiquette of 19th century executions was the place of honor, the position given to the person the state considered the principal. Then, someone took her bonnet off, and someone else raised an umbrella over her head. That is not a detail invented for effect. It is in the photographs. Alexander Gardner's camera was on a rooftop overlooking the yard that day, and in the plates you can see parasols open on the scaffold. They were held over Mary Surratt and over General John Hartranft, the officer in charge of the prisoners, while Hartranft read aloud the findings of the military commission, the sentence of death, and the order of the President of the United States approving it. It took a long time to read. The sun was direct. So a soldier stood behind a woman who had 20 minutes to live and held a parasol over her to keep her comfortable. There is something in that image that tells you more about the United States in the summer of 1865 than any speech from the period. A government that could not bring itself to let her be uncomfortable in the sun, and could not bring itself to let her live. She had asked for one thing that morning, through her priests. She had asked to be allowed to see her daughter one more time. Anna Surratt, 22 years old, had spent the morning at the White House gate and had been turned away. The night before, on the 6th of July, a captain named Christian Rath had gone out to the yard after sunset to tie the nooses. Rath had built the gallows. He was a Michigan man, an officer of the 17th Michigan Infantry, and this was his assignment. He tied 4 ropes. Years later, in 1911, in a long interview published in McClure's magazine, he described what he did that night, and it is one of the most extraordinary admissions any executioner has ever made on the record. "I put 7 knots in each one except one," he said, "and I only put 5 in that, for I fully expected that Mrs. Surratt would never hang. He put 7 in the other 3. 7 is what you use when you intend the rope to work." He gave her 5. He was not being cruel. He was being certain. Christian Rath, the man who built the scaffold and tied the ropes and gave the signal, did not believe until the last minute of the last hour that the government of the United States was actually going to hang a 52-year-old Catholic widow in front of 1,000 ticket holders. Nobody did. That assumption ran from the executioner all the way up to the general commanding, General Winfield Scott Hancock, who had been given personal charge of carrying out the order, stationed himself in the yard where he could be reached fastest, and he did that for a specific stated reason. He positioned himself so that if the president relented and granted a reprieve, not a moment would be lost in reaching him. Hancock had also arranged a relay of riders between the arsenal and the White House. He expected a horse. Everyone expected a horse. No horse came. At somewhere between 1:15 and 1:30, Rath clapped his hands. 4 soldiers knocked out the supports. The surgeons who examined the bodies afterward found that no one's neck had been broken by the fall. All 4 of them strangled. Lewis Powell, who was enormous and young and strong, fought it for nearly 5 minutes, his legs coming up until he was almost sitting in the air. Mary Surratt died quickly. Landon, watching, recorded that she died without a struggle, merely a clenching of the left hand. They cut her body down at 8 minutes before 2. 81 days. Now, everything in the rest of this documentary exists to answer one question, and I want to put the question in front of you plainly before we go any further, because I am not going to pretend to you that it has a comfortable answer. The question is not whether Mary Surratt was innocent. That is the question most people ask, and it is the wrong one, and it is the reason this story has been argued in circles for 160 years. Serious historians disagree about her innocence, and they will keep disagreeing, because the evidence genuinely runs both ways, and I will show you both directions of it without putting my thumb on the scale.
The question is narrower than that, and much harder to escape.
The question is whether the proceeding that killed her was capable of finding out. Because 2 years later, the government took the same conspiracy, the same witnesses, several of the same documents, and a defendant who was, by his own admission, more deeply involved than she ever was, and put all of it in front of 12 ordinary men in a civilian courtroom with a real cross-examination and a real burden of proof. And those 12 men could not agree to convict him of anything at all. Same conspiracy, same evidence, one rope, one jury. Keep watching, because the thing that made the difference between those two outcomes was not new evidence, and it was not a better lawyer. It was a Supreme Court decision handed down in Washington 9 months after Mary Surratt was already in the ground, and what it said was that the court which tried her should never have existed. 3 days after Abraham Lincoln died, at somewhere close to 11 o'clock on the night of the 17th of April, 1865, 4 men from the War Department climbed the steps of a narrow brick townhouse at 541 H Street in Washington and knocked. The house belonged to Mary Surratt. She had been running it as a boarding house since the previous winter. She was already dressed. She had been expecting them for 2 days, because her son's name had been in the newspapers since Sunday. The officers told her to gather her things. She asked to be allowed to kneel and pray first, and they let her. Her daughter Anna was in the house. So were 2 young boarders, Honora Fitzpatrick, who was 20, and Olivia Jenkins, her niece. And then, while the officers were still in the hallway waiting for 4 women to put on their coats, somebody knocked at the front door. The man standing on the step was over 6 feet tall, powerfully built, wearing a gray coat with one sleeve of his undershirt pulled over his head as a makeshift cap. He was carrying a pickaxe over his shoulder. He was covered in mud. He said he had been hired by Mrs. Surratt to dig a gutter, and that he had come to ask what time he should start in the morning. It was 11 o'clock at night. The detectives brought him inside. They brought Mary Surratt into the hall and put a lamp on him and asked her whether she knew this man. She raised her right hand. "Before God, sir, I do not know this man, and have never seen him, and I did not hire him." The man with the pickaxe was Louis Thornton Powell, and 3 nights earlier, he had forced his way into the bedroom of Secretary of State William Seward, who was lying in bed with a broken jaw and a splint on his neck from a carriage accident, and had stabbed him in the face and throat until the blood soaked through the mattress. He had stabbed Seward's son, his nurse, a State Department messenger, and a servant on his way out. Seward survived only because the iron splint on his jaw turned the blade. Powell had been a regular visitor to Mary Surratt's parlor for months. Honora Fitzpatrick had sat with him in that parlor. Anna Surratt had a photograph of him in her room, along with photographs of Jefferson Davis, Alexander Stevens, and John Wilkes Booth, the last one hidden behind a print called Morning, Noon, and Night. He had eaten at Mary Surratt's table. He had stayed in her house. In February, he had checked in under the name Payne, and she had introduced him to the household as a Baptist preacher. Understand what that denial did. Up to that moment, the case against Mary Surratt was a case about a building. Booth had met his conspirators in her parlor. Powell and Atzerodt and Harold had come and gone. Her son had been a Confederate courier who ran dispatches between Richmond and Montreal and used her house as a way station. All of that made her a landlady in a Southern sympathizing city, full of Southern sympathizing households, in a war where half of Maryland had a cousin in the Confederate Army. It made her suspicious. It did not, by itself, make her a murderer. The denial changed the category. The denial was not passive. The denial was an act. She looked at a man she had fed and housed and stood in her own hallway and swore before God that she had never seen him, and it was not true, and there were witnesses in the room who knew it was not true. From that night forward, every piece of ambiguous evidence against her was read through that one sentence. A prosecutor does not need to prove you pulled a trigger if he can prove you lied about knowing the man who did. She was taken first to an annex of the old Capitol Prison. On the 30th of April, she was moved to the Washington Arsenal and put in a cell with 2 armed guards outside it at all times. Here, I want to correct something because it gets repeated constantly and it is wrong. The male conspirators were hooded. They were fitted with padded canvas hoods that covered the entire head and were kept on them for weeks, an act of sensory deprivation so severe that at least one of them appears to have been permanently damaged by it, and they were manacled with rigid iron bars between the wrists. Mary Surratt was not. She was the only prisoner not hooded, and she was not kept in irons. She was 52. She was in poor health. She was suffering from a chronic condition that caused her severe pain and bleeding, and she spent most of the trial lying down in a rocking chair or on a couch behind a screen at the end of the prisoner's dock, holding a palm leaf fan against her face. That distinction matters, and not in the direction you might expect. It tells you that the men running this process knew perfectly well she was a different kind of prisoner. They knew it, and they hanged her anyway. Anna Surratt was arrested too. She was held at the Carroll Annex until the 31st of May. The boarders were arrested. Honora Fitzpatrick was arrested. The Holohan family, a stonecutter and his wife and their 2 children who rented 2 rooms on the 3rd floor, were arrested. Olivia Jenkins was arrested, and a 22-year-old War Department clerk named Louis Weichmann, who had shared a 3rd-floor bedroom and a bed with John Surratt Jr., and who had been Mary Surratt's boarder and her son's closest friend since they were seminary students together at St. Charles College, was arrested. Weichmann was arrested on the 17th of April as a suspected conspirator. 6 weeks later, he was the government's principal witness against the woman whose house he had lived in. Remember his name. We are going to come back to Louis Weichmann twice, and the second time will be in a different courtroom, in 1867, where a defense lawyer with a real right of cross-examination finally got to ask him the question nobody was permitted to ask in 1865. Same conspiracy. Same evidence. One rope, one jury. To understand what the government said Mary Surratt did on the day Lincoln was shot, you first have to understand what she said she was doing. And her account is not vague, and it is not sentimental, and it does not ask you to like her. It is about money. Her husband, John Harrison Surratt Sr., had died in August of 1862. He drank. That is not a slander from a hostile source. It is the settled account of everyone who knew the family. He drank. He made bad bargains. And when he died suddenly, he left his wife with a tavern, a post office, some acres in Prince George's County, a townhouse in Washington, and a wall of debt. She was 39 years old when she was widowed. She had 3 children. Isaac was already gone, off to Texas, and then into the Confederate cavalry. Anna was 19. John Jr. was 17 and had to be pulled out of the seminary to come home and try to run the place. She could not run it. Nobody could have run it.
The property in southern Maryland was worked by enslaved people who were emancipated in Maryland on the 1st of November, 1864. And whatever else you want to say about the moral arithmetic of that, the practical arithmetic for Mary Surratt was that the labor her husband's estate had depended on was gone, and the war had wrecked the tobacco economy around her, and she owed money to people who were now asking for it.
So in the autumn of 1864, she did the only thing a woman in her position could do. She leased out the tavern at Surrattsville to a former Washington policeman named John Lloyd on the 1st of December for $500 a year. She moved to the townhouse in Washington, and she advertised in the Daily Evening Star for boarders. The notice ran on the 30th of November, the 8th of December, and the 27th of December, 1864. Rooms available for 4 gentlemen. That is the position she was in. A 51-year-old widow with failing eyesight, renting out bedrooms in a war capital, trying to hold together an estate that was underwater.
Now, here are the 2 numbers that the entire defense case rests on. The first is $1,000. That was the amount of a note held against the Surrattsville property by a man named George Calvert, of the Calvert family of Maryland, and Calvert wanted it settled. On the 12th of April, 1865, he wrote to Mary Surratt, pressing her for payment. That letter is not a story. It exists. It was produced at the trial and entered into the record as Exhibit 68, and the defense had to formally ask the government to hand it over. The second number is $479. That is the reported balance owed to Mary Surratt by a farmer named John Nothey, who had bought about 75 acres from her late husband and had never finished paying for it. I will flag that figure honestly for you. The debt is documented and entered oath. Nothey testified about it under oath on the 26th of May, 1865. The specific dollar amount is repeated everywhere in the popular literature, and I could not trace it to a court exhibit, so treat it as reported rather than proved. The chain runs like this, and it runs in one direction. Calvert presses Mary Surratt. Mary Surratt has no money. The only money she can reach is the money Nothey owes her, so she has to go to Surrattsville and squeeze Nothey.
She went twice in 3 days. The first trip was Tuesday, the 11th of April, 1865. Louis Weichmann drove her. He had the buggy because John Wilkes Booth had given him $10 to hire one, which is a fact the defense could never explain away, and the prosecution never had to. On the road at Uniontown, they passed John Lloyd, driving with his sister-in-law, Emma Offutt, and the 2 parties stopped and spoke. At Surrattsville, a neighbor named Bennett Gwynn went and talked to Nothey privately on Mary's behalf. Nothey would not settle. They drove home with nothing. The second trip was Friday the 14th of April, 1865. Good Friday. That morning, Calvert's letter arrived. Weichmann had the day off, because Secretary Stanton had given the War Department clerks Good Friday. Mary Surratt asked him to drive her again and suggested he borrow Booth's buggy, and Weichmann went to find Booth and learned Booth had sold the buggy, so Booth gave him money to hire one instead. And then, just as they were leaving, John Wilkes Booth came to the house and handed Mary Surratt a small package wrapped in paper, about 6 inches across, and asked her to carry it to Surrattsville and leave it for Mr. Lloyd. The package contained a pair of field glasses. They reached Surrattsville around 4 in the afternoon. Lloyd was not there. Gwynn was not there. Nothey was not there. Mary Surratt's eyesight was bad enough that she could not comfortably write a letter herself, so she had Weichmann write out a dunning letter to Nothey for her, threatening suit within 10 days if he did not pay, and she signed it and dated it the 14th of April, 1865. That document also exists. It was entered at the trial as Exhibit 67. Sit with that for a second, because it is the strangest fact in the case, and almost nobody says it plainly. On the afternoon of the day Abraham Lincoln was shot, at the very hour the government says she was delivering weapons instructions for the murder, Mary Surratt was sitting in a country tavern dictating a debt collection letter about $479, and she signed it, and the signature is on the exhibit, and the date on it is the 14th of April. Emma Offutt arrived, and Mary handed her Booth's package. Gwynn arrived and took the Nothey letter and read it aloud to Nothey that same day. The buggy needed repairs, which delayed them, and at about 5 o'clock, John Lloyd came back from Marlborough with a load of oysters and fish, and he was drunk. Not tipsy, drunk. His own sister-in-law testified to it under oath. Emma Offutt said he was very much in liquor, more so than I have ever seen him in my life. Bennett Gwynn, who had run into him earlier in the day, said more mildly that he had been drinking right smartly. What happened in the next few minutes between Mary Surratt and John Lloyd in the yard of that tavern is the only piece of evidence in the entire case that puts an assassination day instruction in her mouth. Everything else against her is proximity. This is the one thing that is not. And the only human being who ever reported it was the drunk man. John Lloyd was a former Washington policeman who had leased Mary Surratt's tavern in Surrattsville 4.5 months earlier. He was, by the spring of 1865, drinking very heavily, and he was about to become the single most important witness in the case that hanged her. 5 or 6 weeks before the assassination, in the middle of March, 3 men had come to the tavern at night and left things there. The men were John Surratt Jr., David Harold, and George Atzerodt. Lloyd testified to what they left: 2 carbines with ammunition, a rope 16 to 20 feet long, and a monkey wrench. Think about that inventory for a moment, because it is not the equipment of an assassination. A rope of that length and a wrench are the tools you use to disable a road behind you and tie up a prisoner. Those are kidnapping supplies. That cash had been sitting in the ceiling of Mary Surratt's tavern since March, hidden between the joists in an unfinished room, and it belonged to a plot that everybody involved later admitted to, including her son, in public, from a stage. Now here is what John Lloyd swore Mary Surratt said to him. About the 11th of April, on the first trip, he said she told him to get the weapons out because they would be wanted soon. And about the 14th of April, on the second trip, in the yard, he said this: "She told me to have those shooting irons ready that night. There would be some parties who would call for them. She gave me something wrapped in a piece of paper, a field glass. She told me to get 2 bottles of whiskey ready. That is the sentence. That is the whole case." If those words were spoken, Mary Surratt knowingly armed her son's Confederates on the afternoon of the murder and told them where to find the liquor for the road. If those words were not spoken, or were spoken about the March cash with no knowledge of what had changed, she is a woman who drove 12 miles to collect a debt and carried a neighbor's parcel because she was asked to. Around midnight that night, John Wilkes Booth and David Harold rode into that tavern yard with Booth's leg broken. Harold called out to Lloyd, "For God's sake, make haste and get those things." Lloyd brought out 1 carbine, the rope, the field glasses, and the whiskey. Booth could not carry a carbine with a shattered leg, so they took one. They drank. Booth said something to Lloyd about having killed the president, or words that Lloyd later reported to that effect, and they rode south. Lloyd was arrested on the 18th of April.
And here is where you have to slow down and look at the machinery, because this is the part the military commission was not built to examine.
When they took John Lloyd into custody, he understood exactly what he was. He was a man who had handed weapons to the president's murderer at midnight and sent him on his way. He was, on the face of it, an accessory after the fact to the assassination of Abraham Lincoln, and men were being hanged for less that spring. At the moment of his arrest, he said something that was widely reported and is entirely in character. "Oh, that Mrs. Surratt, that vile woman, she has ruined me. I am to be shot." Read that again. That is not the statement of a witness. That is the statement of a suspect calculating his survival out loud and identifying, in the same breath, the person he is going to hand over. Lloyd did not give up Mary Surratt immediately. He was interrogated intensively by an Army captain named George Cottingham and by Washington detectives over several days before the shooting iron story took its final form. Whether he was physically coerced is contested, and I am not going to overstate it for you. What is not contested is that he was a heavy drinker in custody, that he was interrogated hard, that he was facing a capital charge, and that every incentive operating on him ran in exactly one direction. He was never charged with anything. He testified for the government, and he walked. Now hold the two readings of that sentence side by side, because both of them are reasonable, and this is precisely the sort of thing a jury exists to decide. The innocent reading. Shooting irons means the March cash, which had been in the tavern for a month and which related to a kidnapping scheme. Mary Surratt knew about a plan to abduct the president and carry him to Richmond, which was a real plan, which many Marylanders would have considered legitimate wartime activity, and which was abandoned. She passed a message about property in her own building from a man she trusted, without knowing that Booth had decided 4 hours earlier to commit murder instead. The guilty reading. The timing is too exact. That afternoon, hours before, delivered with Booth's own field glasses in her hands, and a specific instruction about whiskey. You do not tell a man to have the guns ready that night unless you know something is happening that night. Both readings survive the evidence. That is the honest position, and the reason this case has never closed.
But notice what a proper trial would have done with John Lloyd. A defense lawyer with time and subpoena power would have put Emma Offutt on the stand to say he was more drunk than she had ever seen him. He would have put Bennett Gwynn on to say the man had been drinking right smartly since Marlborough.
He would have walked the jury through the arrest, the capital exposure, the interrogation, the immunity, and that one sentence, "She has ruined me. I am to be shot." He would have asked the jury to decide how much weight to put on the memory of an intoxicated man who was saving his own life. That is not a trick. That is cross-examination. That is the ordinary daily work of a criminal court. It did not happen in 1865, and the reason it did not happen is that Mary Surratt was not in a criminal court. 2 years later, in 1867, John Lloyd testified again. Same man, same story, this time against her son, in a civilian courtroom with a real defense. That jury would not convict. Same conspiracy, same evidence, one rope, one jury. Before we go on, one small thing. If you find this useful, subscribing genuinely helps this channel keep making them at this length and this level of sourcing. That is the whole ask. Now let us look at the court that tried her. On the 1st of May, 1865, President Andrew Johnson signed an executive order
It directed that the people accused of conspiring to murder Abraham Lincoln be tried not in the courts of the District of Columbia, which were open and functioning and sitting for criminal business every day that spring, but before a military commission. That single decision is the hinge of this entire story. Everything else follows from it. The commission convened on the 8th of May, 1865. Proceedings began on the 9th. Testimony started on the 12th. 9 officers sat in judgment. Major General David Hunter presided. With him sat Major General Lew Wallace, who would later write Ben-Hur, Brigadier General August Kautz, Brigadier General Albion Howe, Brigadier General Robert Foster, Brigadier General James Ekin, Brigadier General Thomas Harris, Brevet Colonel Charles Tompkins, and Lieutenant Colonel David Clendenin. Prosecuting was Judge Advocate General Joseph Holt, with John Bingham and Henry Burnett assisting. Now compare the rules of that room to the rules of an American criminal court, because the differences are not technicalities. Each one of them is a piece of protection that was removed. In a criminal court, the jury must be unanimous. In this room, a simple majority convicted. In a criminal court, a death sentence requires that same unanimity. In this room, 6 of the 9 officers could send a defendant to the gallows. In a criminal court, the defendant is entitled to appeal. From this room, there was no appeal to any court in the United States. The only review was the president, who had ordered the commission into existence in the first place. In a criminal court, the rules of evidence exclude hearsay and irrelevant, prejudicial material. In this room, the commission admitted a vast quantity of testimony about Confederate atrocities, prison camps, and an alleged plot by the Richmond government to spread yellow fever in northern cities, none of which had anything to do with whether a Maryland widow knew what was in a package. In a criminal court, the accused chooses counsel freely. Mary Surratt did choose counsel freely, and here is what happened to him. She retained Reverdy Johnson, who was a United States Senator from Maryland, a former Attorney General of the United States, and one of the most formidable constitutional lawyers alive. He had argued Dred Scott. If you wanted someone in 1865 to walk into a military tribunal and tear the jurisdiction to pieces, Reverdy Johnson was the man in America you would pick. He appeared. And on the first day, a member of the commission challenged his right to be there, on the ground that Johnson had publicly questioned the binding force of a loyalty oath imposed on Maryland voters in the 1864 election. The objection was, on any reading, an attack on his patriotism rather than his standing. The objection was withdrawn. But Reverdy Johnson barely came back. He argued the jurisdictional question in writing, and then absented himself from most of the sessions. Contemporary accounts attribute the challenge to General Thomas Harris and place it around the 12th of May, and I will flag for you that I could not nail that to a primary document, so treat the specific day and the specific accuser as probable rather than certain. What is certain is the result. Mary Surratt's defense passed to Frederick Aiken and John Clampett. Aiken was 28 years old. Clampett was 26. Neither had ever tried a capital case. They were handed a client facing execution, in a court with no rules they had trained for, against the Judge Advocate General of the United States Army, with a few weeks to prepare, in a city that wanted blood. They were not incompetent. Read the record, and you find 2 young men working extremely hard. Aiken's closing argument for her is a serious piece of advocacy. But you cannot manufacture experience, and you cannot investigate 100 witnesses in a month, and you could not, in that room, do the one thing that might have saved her,
which was to take John Lloyd apart slowly in front of 12 skeptical citizens. The trial ran roughly 7 weeks. Something in the region of 350 to 370 witnesses were heard against the 8 defendants, and the published counts differ. Mary Surratt spent most of it lying down behind a screen with a fan over her face. She never testified. She could not. Under the law, as it stood in 1865, a criminal defendant in most American courts was not competent to testify in their own defense at all. The rule was that a defendant's interest in the outcome made their word worthless. It sounds insane now. It was standard then. So the woman on trial for her life sat in a hot room for 7 weeks, and was never permitted to say a single word about what she had done, or why she had driven to Surrattsville, or what she thought was in the package. On the 30th of June, 1865, the commission reached its findings. Samuel Arnold, life. Dr. Samuel Mudd, life. Michael O'Laughlin, life. Edmund Spangler, 6 years. David Harold, George Atzerodt, Louis Powell, and Mary Surratt, death by hanging. And then, at the bottom of the findings, 5 of the 9 officers who had just voted to hang her wrote something down. The Clemency Petition is a short document, and it is worth hearing in full, because the men who wrote it had just spent 7 weeks listening to every word of evidence in the case, and because what they wrote tells you they did not believe what they had just done. The undersigned members of the Military Commission, detailed to try Mary E. Surratt and others for the conspiracy and the murder of Abraham Lincoln, late President of the United States, respectfully pray the President, in consideration of the sex and age of the said Mary E. Surratt, if he can, upon all the facts in the case, find it consistent with his sense of duty to the country, to commute the sentence of death, which the court have been constrained to pronounce, to imprisonment in the penitentiary for life. 5 of the 9 signed it. Read the phrasing again, slowly, because it is a strange and revealing piece of writing, which the court have been constrained to pronounce. Constrained. These are the judges. Nobody constrained them. They wrote the sentence themselves, and then within hours of writing it, they described their own verdict as something forced on them from outside. That is the sound of men who have just done something under pressure and want it on the record that they were under pressure. The grounds they gave were her sex and her age, not her innocence. They did not say she was innocent, and I am not going to tell you they thought she was. They said that a 52-year-old woman should not hang for this, and they asked the President to make it life in prison instead. Which 5 signed is a question I want to be careful about. Every popular account names Hunter, Couts, Foster, Ekin, and Tompkins, and that is probably right. But I could not confirm the roster from the original document, so take the names as the standard attribution rather than as verified fact. The petition was written on the 30th of June, 1865. Joseph Holt did not put it in front of Andrew Johnson until the 5th of July. 5 days. And the 5th of July is the day Johnson signed the death warrant, and the day he set the execution for the 7th, giving the condemned less than 48 hours. So the question that has been argued for 160 years is simply this. In that meeting on the 5th of July, did the President of the United States actually see the paper? Holt said yes, for the rest of his life. He said he laid the petition before Johnson, that Johnson read it, and that Johnson declined to act. Holt was so tormented by the accusation that he spent decades publishing vindications of himself,
collecting affidavits, pursuing the question into old age like a man trying to scrub something off his hands. Johnson said no. He said, late in his life, that no appeal ever reached him, that Mary Surratt's daughter had sent one, and that Secretary Stanton had suppressed it, and that he heard of it afterward but never saw it. I have to flag that quotation for you, because it matters. Those words come from a recollection by a man named McElwee of things Johnson said on his last journey, and they were published in a Greenville newspaper in 1923, 48 years after Johnson died, and the National Park Service itself notes that McElwee was not attempting to quote the exact words. So it is a memory of a memory. Use it as the shape of Johnson's later position, not as a sentence out of his mouth. But here is the thing that damages Johnson badly, and it is on the record, in his own voice, in public, while he was alive to be contradicted. On the 28th of October, 1874, speaking in Chattanooga, Andrew Johnson said this about Mary Surratt: "There was no ground for pardon, except for that she was a woman." Here we begin to see a sort of sympathy with conspirators. All that I did was to let the law take its course. That is not the statement of a man who never heard an appeal. That is the statement of a man who considered an appeal, identified its exact grounds, which were precisely the grounds the 5 commissioners had written down, and rejected it with contempt. The physical petition still exists in the National Archives. It carries a file endorsement. What no document anywhere establishes is whether the paper was opened in front of the president or slid past him inside a stack. Historians divide on it, and the honest ones say it is unresolved. I am telling you that plainly, instead of picking the version that makes a better story. What is not unresolved is the calendar. The commission signed the petition on the 30th of June. The Judge Advocate General held it for 5 days. The President saw the file, or did not, on the 5th of July. The warrant was signed the same day. The execution was set for the 7th. Whatever happened in that room, the structure of the thing guaranteed that the only human being with power to stop it had, at most, 48 hours to think about it, and the paperwork reached him in a bundle with the death warrant. There is one more part of this, and it is the part that gets left out. Colonel William Wood, the superintendent of the old Capitol prison, believed Mary Surratt was innocent. On the morning of the 7th of July, he tried to get to Andrew Johnson to say so. He was blocked from reaching the president by Lafayette Baker, the head of the National Detective Police, acting on the authority of Secretary of War Edwin Stanton. Same conspiracy, same evidence. One rope, one jury. Frederick Aiken and John Clampett, the 2 young lawyers, did not give up when the warrant was signed. On the night of the 6th of July, 1865, they did something genuinely audacious. They went and woke up a judge. At 2 or 3 in the morning on the 7th of July, and the accounts differ on the hour, they arrived at the home of Andrew Wylie, a justice of the Supreme Court of the District of Columbia, and asked him to issue a writ of habeas corpus for the body of Mary Surratt. Habeas corpus is the oldest protection in the Anglo-American legal tradition, and the simplest. It is a command to whoever is holding a prisoner to bring that prisoner physically into court and show the legal authority for holding them. It is not a claim of innocence. It is a demand that the state justify itself in front of a judge. Wylie knew exactly what he was being asked to do. He was being asked, in the middle of the night, to put a civilian court in the path of a military execution ordered by the President of the United States, with the sun already coming up on the day it was scheduled. He signed it.
Let the writ issue as prayed, returnable before the criminal court of the District of Columbia, now sitting at the hour of 10 o'clock a.m., this 7th day of July, 1865. Read the middle of that. Now sitting. The civilian criminal court of the District of Columbia was in session. It was open. It was doing business that morning, like any other morning. Hold on to that fact. In about 40 minutes of this documentary, it is going to come back and detonate. The writ was served on General Winfield Scott Hancock, commanding, and it required him to produce Mary Surratt in a courtroom at 10 in the morning. And at 10 in the morning, this was endorsed on the writ. Executive Office, July 7th, 1865, 10 a.m. The President of the United States declared that the writ of habeas corpus had heretofore been suspended in such cases as this, and directed that the order upon the judgment of the Military Commission be carried out. Andrew Johnson had personally suspended the writ that morning for that one woman, 3 hours before her execution. At 11:30, General Hancock came into Judge Wylie's courtroom, in person, with the Attorney General of the United States beside him, and made his return. He told the court that Mary Surratt remained in his possession, under and by virtue of an order of Andrew Johnson, President of the United States. He did not bring her. He could not. He was telling a federal judge, respectfully, that the executive branch was not going to comply. Judge Wylie said, for the record, that the court had been overruled by a superior force and could take the matter no further. That is one of the only occasions in the entire history of the United States on which the executive branch openly disregarded a judicial order in a capital case. It happened at 11:30 in the morning. She was dead 90 minutes later. The legal authority Johnson relied on was the Habeas Corpus Suspension Act of 1863, passed at the height of the war. Whether it reached this case, 3 months after Appomattox, in a city where the courts had never closed, is a question that was never litigated, because the only person with standing to litigate it was hanged before lunch. I want to be exact about what this does and does not prove. It does not prove Mary Surratt was innocent. It proves that on the last morning of her life, when a civilian judge tried to examine whether the government had lawful authority to kill her, the government's answer was that the question would not be entertained. Same conspiracy, same evidence, one rope, one jury. Anna Surratt was 22 years old. She had been arrested with her mother in April and held for 6 weeks. She had testified for the defense on the 30th of May and again on the 7th of June, and she had broken down on the stand both times so badly that the record notes her distress. She had spent 7 weeks watching her mother lie behind a screen in a military courtroom. On the 6th of July, at noon, Mary Surratt was told she would be hanged the next day. She wept, and then she asked for her daughter. At 8 o'clock on the morning of the 7th of July, Anna Surratt left the arsenal and went to the White House. She was not alone. A family friend named John Brophy went with her. So did Charles Mason, a former commissioner of patents. Adele Cutts Douglas, the widow of Senator Stephen Douglas, went too, and Adele Douglas was not a woman who could be easily dismissed in Washington. She was beautiful, she was extremely well connected, and she was the widow of the man who had run against Abraham Lincoln for the presidency. Adele Douglas pushed past the guards and got up the stairs. Twice. She was turned back both times. Anna Surratt never got that far. 2 men stopped her. One was Preston King, a former United States Senator from New York, who was serving as Johnson's gatekeeper and had just been appointed collector of the Port of New York. The other was James Lane, a sitting United States Senator from Kansas. They told her the president was not receiving visitors that day. She went back. She was sent to Joseph Holt. Holt sent her back to the president. She returned to the White House and was refused again. At around 11 o'clock in the morning, having failed, Anna Surratt went back to the arsenal to sit with her mother for the last 2 hours. 2 days later, on the 9th of July, she wrote a letter to General John Hartranft, the officer who had read the death warrant on the scaffold. What she wrote about her treatment at the executive mansion was this: she had been spurned and treated with the utmost contempt by everyone at the White House. The rest of that letter is the part that stays with you. She asked him not to forget to send the pillow upon which her mother's head had rested, and her prayer beads, if he could find them. On the 8th of July, she wrote to Edwin Stanton and asked for the body. She wrote that her mother had lived a Christian life and died a Christian death and deserved a Christian burial. Stanton refused. The stated reason was that a grave would become a shrine. Mary Surratt was buried in a pine gun box in a shallow trench against the prison wall, a few feet from the gallows, with her name written on a slip of paper and sealed inside a glass vial and laid in the coffin with her, because the government understood perfectly well that one day somebody would need to identify what was in the ground. A white picket fence was put around the 4 graves. It took Anna Surratt 3 years and 7 months to get her mother back. She petitioned Andrew Johnson on the 3rd of February, 1869, in the last weeks of his presidency, and this time he wrote across it that the Secretary of War would cause the remains of her mother to be delivered to Anna E. Surratt. The body was released on the 8th of February and reburied at Mount Olivet Cemetery in Washington on the 9th. Now here is a fact that gets used badly, and I am going to give it to you straight and then tell you what it does not mean. Preston King, the man who turned Anna Surratt away from the White House door, walked onto a ferry boat in New York Harbor on the 13th of November, 1865, 4 months later, with a bag of bullets tied around his neck, and jumped into the water. James Lane, the senator who stood beside him, shot himself near Fort Leavenworth, Kansas, on the 1st of July, 1866, and died 10 days later. Both men are dead by their own hand within a year of that morning. Both facts are documented, and neither is in dispute. And every popular telling of this story puts those 2 deaths right after the White House scene and lets you draw the obvious conclusion, and the obvious conclusion is not supported. Preston King was under crushing political pressure at the New York Custom House, which was the most corrupt patronage post in the United States, and he was by all accounts in serious mental decline. James Lane was facing a corruption investigation, had just been repudiated by his own state for supporting Johnson, and had a long documented history of mental illness. The deaths happened. The causation is a story people tell because it is satisfying. I am not going to sell it to you. This documentary does not need it. What happened to Mary Surratt is bad enough without decorating it. Same conspiracy, same evidence. One rope, one jury. We began this documentary on the scaffold, and now that you know how she got there, we are going back to it once, in full, because the details of that afternoon are the clearest evidence in the entire case of what the people carrying out the sentence actually believed. The yard of the old Arsenal Penitentiary held about 1,000 people that day. Admission was by ticket. General Hancock had ordered it that way. Alexander Gardner, who had photographed Antietam and had photographed Lincoln, was on a roof above the yard with his camera. The plates he made that afternoon are the only sequential photographic record of a judicial execution in 19th century America, and they are the reason we can check the written accounts against the physical evidence. At 1 o'clock, the door opened, and Mary Surratt came out, veiled and in black, leaning on 2 men, with 2 priests behind her. She was helped up the 13 steps and seated at the right end. Her bonnet was taken off. An umbrella was raised over her head and over General Hartranft while he read the findings, the sentence, and the president's order. The prisoner's arms were bound. Strips of white cloth were tied around their legs at the thighs and ankles. Then the white caps went over their heads and the nooses went around their necks. There is a moment recorded in several accounts when they were adjusting the rope on her, and she said something about her arms being bound too tightly, and one of the officers is supposed to have answered that it would not hurt long. The condemned stood on the drop for something close to 10 seconds. Christian Wrath clapped his hands. 4 soldiers with heavy poles knocked out the supports under the 2 drops. Sergeant Landon, who was standing in the yard, wrote afterward that the ropes were adjusted, the white caps pulled over their heads, and they were literally jerked into eternity. The examining surgeons afterward found that not one of the 4 had died from a broken neck. Every one of them strangled. Mary Surratt, Landon wrote, died without a struggle, merely a clenching of the left hand. Louis Powell fought for close to 5 minutes. He was 21 years old and built like a farm animal, and his body swung and twisted, and his legs came up until he was nearly sitting in the air. David Harold and George Atzerodt, Landon wrote, were both half dead with terror before it started, and their knees knocked together. Atzerott's last words are on firm contemporary footing. He said, "May we meet in another world." And then, as the rope was set, he said, "Do not choke me." Mary Surratt's last words are not on firm footing, and I am going to be straight with you about that, because they are quoted everywhere. Please do not let me fall. That line appears in later retellings. It is not in the New York Herald's On the Scene account from the 8th of July, which says only that Mrs. Surratt and Payne preserved their stolid indifference to the end. It may be true. It is not documented the way the rest of this is, and I am not going to put words in a dying woman's mouth to give you a better ending. The bodies hung for about 25 minutes. They began cutting them down at 7 minutes before 2. Mary Surratt's body came down at 2 minutes before 2. Now, Christian Wrath, the man who tied the ropes, gave her a 5-knot noose because he did not believe she would hang. He was wrong. Wrath was haunted by it for the rest of his life. He said so. He believed she was innocent, and in his later years he converted to Christian Science, in part, by his own account, because he was afraid of what would happen to him after death for having executed an innocent woman. General Hancock stationed himself for a rider that never came. Colonel Wood, who ran the prison she had been held in, tried to reach the president that morning to say she should not die and was physically prevented. 5 of the 9 officers who condemned her had signed a paper asking for her life.
I want you to notice what that list actually is. That is not a list of her defenders. Not one of those men was on her side. They are the executioner, the commanding general, the warden, and the judges. They are the machine itself.
And the machine did it anyway. That is what a proceeding with no jury, no appeal, and a majority vote for death produces. It produces an outcome that almost nobody operating it wanted, and that nobody operating it could stop, because the structure was built so that no single conscience anywhere in it had the power to say no. 81 days. Now we go and find her son. Here is something that almost never gets said about the trial of Mary Surratt. The government's own theory of her guilt depended entirely on her son. Read the charge. She was accused of maintaining a house where the conspirators met, of aiding and harboring them, and of assisting the plot. But the reason Booth was in her parlor at all, the reason Powell and Surratt and Harold had the run of her hallway, the reason there were carbines in the ceiling of her tavern, was John Harrison Surratt, Jr. He was 20 years old. He was a Confederate courier. He had been carrying dispatches between Richmond and Montreal for 2 years, using his mother's tavern in southern Maryland as a relay point on the secret line, and after they moved to Washington, he brought the work into her house. He was the one who introduced Booth to the household in December of 1864. He was the one who recruited Surratt, who knew the river crossings. He was the one who, with Harold and Surratt, carried the carbines and the rope and the wrench down to Surrattsville in March and hid them in the ceiling. He was, by every account, including his own, an active and enthusiastic member of the conspiracy to kidnap the President of the United States. Mary Surratt's proximity to the plot was, in every documented instance, her proximity to her son. And when the government came looking on the 17th of April, he was not there. He had left Washington on the 3rd of April, 1865. He had gone to Montreal, and then, on the instructions of a Confederate agent named General Edwin Lee, he had traveled to Elmira, New York, to scout the prisoner of war camp there. He arrived in Elmira on the 12th of April and registered at the Brainerd House under the name John Harrison, which was his own first and middle name. Lincoln was shot on the evening of Friday the 14th of April. On Saturday morning, John Surratt took a seat at a breakfast table in a hotel in Elmira, New York, and picked up a newspaper. He described the moment himself, 5 years later, on a stage in Maryland. I gazed upon my name, the letters of which seemed to sometimes grow as large as mountains, and then dwindle away to nothing. He ran. He took a train north to Canandaigua and signed the register of the Webster House, again as John Harrison. On Easter Sunday, the 16th of April, he went to Mass at St. Mary's Catholic Church in Canandaigua. He learned there was no train until Monday. He waited. On Monday, the 17th of April, he left at noon for Albany. That was the same day the soldiers walked up the steps on H Street and arrested his mother. He got to Montreal. The War Department issued a reward poster. Booth was worth $50,000. Harold and Surratt were worth $25,000 each. John Surratt's name and face went out across the continent, alongside the 2 men who had actually done it. The government wanted him badly, and it did not get him, and it hanged his mother instead. That is not my characterization. It is the plain sequence of the calendar. I want to be careful here, because there is a version of this story that is emotionally satisfying and factually unsupported, and it is that John Surratt could have come back and saved her and chose not to. Look at what he could actually have done. He was in Canada, under an alias, sheltered by priests, with a $25,000 price on his head, named in every newspaper in North America as one of the men who killed Abraham Lincoln. If he had walked into Washington in May of 1865, he would not have testified for his mother. He would have been the 9th defendant in that same military commission, and he would have hanged beside her, and there is no serious reading of that court in which anything else happens. He did know she was on trial. There is a letter, and there are witnesses who put the knowledge in his hands. What he did was stay hidden, and what happened to his mother happened. Whether that makes him a coward is a moral question, and you are entitled to your own answer. I would only point out that the government of the United States had constructed a proceeding in which the only way for him to help her was to die with her, and that is not really a choice, it is a trap, and the trap was not his design. The point that matters for this documentary is narrower and colder. John Surratt was the more culpable Surratt. That is not close. He was in the plot. He armed the plot. He recruited for the plot. And he admitted all of it in public. His mother was hanged 81 days after her arrest by a tribunal with no appeal. He was arrested eventually. He came home eventually. He got a courtroom, a jury, a real defense, and the full protection of the Constitution of the United States. He walked. Same conspiracy, same evidence. One rope, one jury. Now let us go and get him, because the 18 months between that breakfast table in Elmira and a prison cell in Alexandria, Egypt, is one of the strangest manhunts of the 19th century, and it ends with an American fugitive in the uniform of the Pope's army jumping off a cliff. John Surratt crossed into Canada in the last days of April 1865, and the Catholic Church hid him for 5 months. That sentence has been used for 150 years to sell conspiracy theories, and I want to separate what is documented from what is invented, because the invented version has done real damage. What is documented is this. Surratt reached Montreal, where the Confederate Secret Service maintained an established presence, and where he had been running dispatches for 2 years. He was passed into the care of a priest named Charles Boucher, who kept him at the parish of Saint Liboire, a village about 50 miles east of Montreal, through the summer and into the autumn of 1865. Boucher later testified about it, under oath, in Washington, at his trial. Another priest, Father Lapierre, sheltered him in Montreal itself. He was moved several times. He grew a beard and dyed his hair. What is not documented, and what I want to be blunt about, is the elaborate 19th century Protestant conspiracy literature that turned this into a Vatican plot to murder Abraham Lincoln. There is a whole genre of it. It is anti-Catholic polemic, it was politically useful at the time, and it is worthless as history. What actually happened is simpler and more human. A 20-year-old Catholic boy whose mother was in a Washington prison turned up at the door of a rural Quebec parish, and rural Quebec priests in 1865 did not hand fugitives to the United States Army. He was at Saint Liboire when his mother was tried. He was at Saint Liboire on the 7th of July, 1865. Boucher's account is that Surratt learned of the execution from a newspaper and collapsed, and was ill for days afterward. I will mark that as the priest's recollection rather than as independent fact, but it is the only account there is, and Boucher gave it on oath in a courtroom where he had nothing to gain. In September of 1865, he was moved down the St. Lawrence to Quebec City, and on the 16th of September, 1865, he boarded the steamer Peruvian for Liverpool, carried aboard, by one account, in a covered carriage and hidden in the ship. He sailed under the name McCarty. Aboard the Peruvian was the ship's surgeon, a man named Louis Macmillan, and here John Surratt made the mistake that eventually destroyed his anonymity. He talked, Macmillan later testified that Surratt told him who he was and boasted about it. According to Macmillan, Surratt said he had been in the conspiracy and said something to the effect that if he lived, he would finish what Booth had started. Surratt denied ever saying it. Macmillan repeated it under oath in 1867 and was cross-examined on it for hours. That is the pattern of this entire 18-month flight, and it is the most human thing about it. John Surratt could not keep quiet. He was 21 years old. He was the most wanted man in North America, and he kept telling people who he was. From Liverpool, he went to London, then to Paris, then to Rome. And in Rome, in the spring of 1866, John Harrison Surratt Jr., whose mother had been hanged for the murder of the President of the United States 8 months earlier, enlisted as a private soldier in the Papal Zouaves under the name John Watson. The Zouaves were the international volunteer regiment raised to defend the Papal States, which were then in their last years, against Italian unification. They took Catholic volunteers from all over the world: Irishmen, Frenchmen, Dutchmen, Canadians. Nobody asked many questions. He was posted to a garrison at Velletri and later at Veroli, in the hills southeast of Rome. He wore the uniform. He drew the pay. He drilled. And in his company, there was another volunteer, a man he had known slightly in Maryland, a Canadian of French descent named Henri Beaumont de Sainte-Marie. Sainte-Marie recognized him, and Sainte-Marie knew there was a reward. Henri Beaumont de Sainte-Marie went to the American legation in Rome in April of 1866 and told Rufus King, the United States minister, that a private soldier in the Papal Zouaves, calling himself John Watson, was in fact John Surratt. Then he waited 7 months for anybody to do anything about it. The correspondence sat. It went from Rome to Washington and back. Nobody was in a hurry. This is worth sitting with, because it tells you something about how much the United States government actually wanted John Surratt by 1866. His mother had been dead for 9 months. The war was over. Andrew Johnson was in an open political war with his own Congress. The appetite for hanging conspirators had gone. Finally, in November, the order came. The papal government, which had no extradition treaty with the United States and did not need one, agreed to hand him over as a courtesy. On the 7th of November, 1866, John Surratt was arrested at the barracks at Veroli. On the night of the 8th of November, he asked his guards to let him use the privy at the back of the barracks. 6 guards were with him. He went out, and instead of going to the privy, he went over a balustrade at the edge of the terrace and dropped into the dark. How far he fell is one of the great small disputes of this story, and I love it, because it is a perfect demonstration of how a fact gets manufactured. Captain de Lambelie, the officer responsible, sent his first telegram that night and reported that the drop was more than 100 feet deep. In his later written account, de Lambelie said the ledge was at least 35 feet below. When Colonel Allett investigated, the height was recorded as 23 feet, and John Surratt himself, describing it afterward, said it was about 12 feet. You can watch the number shrink, in exact proportion to the professional embarrassment of the man reporting it. 100 feet on the night the prisoner escapes. 23 feet once somebody measures. De Lambelie added one detail in his report that is worth having, because it is both true and unimprovable. The landing was broken by filth from the barracks accumulated on the rock, and he wrote that had the prisoner leaped a little further, he would have fallen into the abyss. John Surratt escaped the custody of the army of the Pope by jumping onto a pile of latrine waste. He got south into the hills, was sheltered by Garibaldians, who were the sworn enemies of the papal government, and were delighted to hide a man who had just embarrassed it, and reached Naples. From Naples, he boarded a British steamer called the Tripoli, still in his Zouave uniform, and sailed for Egypt. Alexandria was the wrong choice. It was the one port where the United States had a consul general who was paying attention. The Tripoli arrived at Alexandria on the 23rd of November, 1866, and was held in quarantine. Charles Hale, the American consul general, went down to the quarantine ground and walked among 78 third-class passengers, looking for a man he had been warned about, and he found him almost immediately, partly, as he wrote in his official dispatch, because of the man's almost unmistakable American type of countenance. Hale recorded the conversation. "You are the man I want. You are an American." "Yes, sir, I am. You doubtless know why I want you. What is your name?" "Walters." "I believe your true name is Surratt." Hale's formal dispatch recording the arrest is dated the 27th of November. On the 29th, he was transferred under guard from the quarantine ground to the government prison in Alexandria, where, as Hale reported to Secretary Seward, he maintained his demeanor of reticence. Hale's telegram reached the War Department in Washington on the 2nd of December, 1866, at 6:15 in the evening. It is 14 words long. "Have arrested John Surratt, one of President Lincoln's assassins. No doubt of identity. Hale, Alexandria. Hale, Alexandria." The United States sent a warship for him. The USS Swatara was a screw sloop of war, 216 feet long, 10 guns, 16 officers, 126 enlisted men, and 15 Marines, under Commander William Jefferson. She was diverted from the Mediterranean squadron to collect one prisoner. The ship's log records the moment. On the 20th of December, 1866, at 1 in the afternoon, received on board a person delivered by the U.S. Consul General, Mr. Charles Hale, supposed to be John H. Surratt. Jeffers took no chances at all. Surratt was kept in single irons in a locked compartment for the entire voyage. He was let out only when it was necessary to use the captain's water closet, and his food was diced up and served to him with a spoon, because Commander Jeffers was not going to give the last Lincoln conspirator a knife. They left Alexandria on the 26th of December, 1866, Port Mahon on the 2nd of January, Villefranche on the 5th, Madeira on the 23rd, Hampton Roads on the 16th of February, 1867. At 20 minutes to 5 on the afternoon of the 18th of February, 1867, the Swatara tied up at the Washington Navy Yard, and John Harrison Surratt, Jr. was handed over to acting United States Marshal David Gooding. He had been gone 1 year, 10 months, and 2 weeks. His mother had been in the ground, in an unmarked trench inside a prison yard about 2 miles from where he was standing, for 1 year, 7 months, and 11 days. One footnote on Sainte Marie, because it is a small piece of grim comedy. He sued for the $25,000 reward. Congress paid him $10,000 instead, by act of the 27th of July, 1868. He sued for the rest. The Court of Claims held that what he had done was merely the giving of information, rather than an apprehension. The Supreme Court of the United States affirmed against him in 1875, holding that the reward offer had been revocable and had in fact been revoked on the 24th of November, 1865, which was before he had done anything at all. The man who found John Surratt got about 40 cents on the dollar and a Supreme Court opinion explaining why he was not entitled to it. While John Surratt was drilling in a papal uniform in the hills outside Rome, the Supreme Court of the United States was deciding a case about an Indiana lawyer named Lambden Milligan, and the decision it reached destroyed the legal foundation of the court that had hanged his mother. Milligan was a copperhead. He was a Confederate sympathizer in a Union state, and in 1864 the Army arrested him in Indiana, tried him before a military commission, convicted him of conspiring against the United States, and sentenced him to hang. He petitioned for habeas corpus. He argued that Indiana was not a war zone, that the civilian courts of Indiana had been open and functioning the entire time, and that the Army therefore had no business trying him at all. The Supreme Court announced its judgment on the 3rd of April, 1866, and delivered the full written opinions on the 17th of December, 1866. It agreed with him unanimously as to the result. The majority opinion was written by Justice David Davis, and there is something almost unbearable about that, because David Davis was Abraham Lincoln's friend. He had been Lincoln's campaign manager in 1860. Lincoln had put him on the Supreme Court, and it was Lincoln's own man who wrote the opinion that said the court which tried the people who murdered Lincoln should never have sat. Here is the language, and I want you to hear it in full, because there is no paraphrase that improves it. The Constitution of the United States is a law for rulers and people, equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances. And then the holding itself. Martial rule can never exist where the courts are open, and in the proper and unobstructed exercise of their jurisdiction. The necessity must be actual and present, the invasion real, such as effectually closes the courts and deposes the civil administration. Now go back to 2 o'clock in the morning on the 7th of July, 1865, and Judge Andrew Wylie signing that writ, and the words he wrote on it, returnable before the Criminal Court of the District of Columbia, now sitting. Now sitting. The civilian criminal courts of the District of Columbia were open the entire time Mary Surratt was tried. They were open on the day she was arrested. They were open every day of the 7 weeks of the military commission. They were open on the morning of her execution, sitting for business, which is exactly why her lawyers were able to find a judge and get a writ at all. Under the rule, the Supreme Court of the United States announced 9 months after they buried her against the prison wall. The tribunal that condemned Mary Surratt had no lawful authority to try her. I want to be precise about what that does and does not mean, because this is the point where documentaries usually overreach, and I am not going to. Milligan did not make her innocent. It says nothing whatever about whether she armed the conspirators or knew what was in the package. A civilian jury might have convicted her. It might have hanged her. Milligan does not apply backwards. It could not reach into 1865 and undo anything. There was nobody left to release. And there are historians who will argue, with a straight face and some force, that Milligan is distinguishable, because the assassination of the commander-in-chief in a fortified capital during a war that was not yet formally over is not the same thing as an Indiana lawyer giving speeches.
But here is the thing that no argument gets around, and it is not a matter of interpretation. It is a matter of what the government itself did next. The United States government had John Surratt in irons in February of 1867. It had him for the same conspiracy. It had a defendant who was, by any measure, more deeply and more knowingly involved than his mother had ever been.
It could have convened a military commission. The machinery still existed. The officers were still alive. Joseph Holt was still the Judge Advocate General. The precedent was 18 months old, and it had worked perfectly the first time, in the sense that it had produced 4 bodies in 81 days. They did not do it. They put him in the criminal court of the District of Columbia, in front of 12 civilians, with a real defense and the full protection of the Constitution. Ask yourself why. They did not do it because they had grown merciful. They did it because after Milligan, they could not. The Supreme Court had closed that door, and everyone in Washington knew it, and the government of the United States understood perfectly well that the tribunal which had hanged Mary Surratt would not survive contact with a real appellate court. That is the answer to the question this documentary opened with. That is what changed between the two proceedings. Not new evidence, not a better lawyer, not a change of heart. A Supreme Court decision that arrived 9 months after she was already dead. Same conspiracy, same evidence. 1 rope, 1 jury. The trial of John H. Surratt for the murder of Abraham Lincoln began on Monday the 10th of June, 1867, in the criminal court of the District of Columbia. Presiding was Judge George Fisher. Fisher was a Delaware Unionist, a former congressman, and, in a detail the defense never stopped mentioning, a Lincoln appointee. Lincoln had nominated him to that bench in March of 1863 for the United States. Edward Carrington, the United States Attorney for the district, Nathaniel Wilson as his assistant, Albert Gallatin Riddle, and, brought in specially from New York to be the government's voice in the courtroom, Edwards Pierpont. For the prisoner, Joseph Bradley Sr., one of the great trial lawyers of the Washington Bar, his son Joseph Bradley Jr., and Richard Merrick. Notice what has already changed. Before a word of evidence, Mary Surratt had a 28-year-old and a 26-year-old who had never tried a capital case. Her son had one of the most experienced criminal advocates in the District of Columbia, with 2 juniors, and the whole thing was paid for by public subscription and by the sale of the family's remaining property. The indictment charged John Surratt with the murder of Abraham Lincoln as a principal in the 2nd degree, meaning as an aider and abettor, not conspiracy, murder. If convicted, he would hang. And then came the jury, and this is where the case was actually decided, though nobody in the room knew it yet. The panel was drawn from 100 residents of the District of Columbia. 12 were seated. The foreman was William Todd. The others were Robert Ball, Russell Barr, Thomas Berry, George Borer, Benjamin Morsell, James Davis, Columbus Alexander, William McLean, Christian Schneider, Benjamin Gettings, and William Berth. Now, Washington, District of Columbia, in 1867, was not a northern city. It was a southern city that happened to contain the federal government. It sat between Maryland and Virginia. Its population was full of people whose sympathies during the war had run the other way, and unlike a state, the district had no loyalty oath requirement for jury service that could screen them out. During the selection, a prospective juror named George Borer stated openly, on the record in front of the judge and both counsel, that he could not have convicted Mrs. Surratt on the evidence. He was sworn onto the jury anyway.
Read that twice. A man who had publicly announced that he considered the mother's conviction unsupported by the evidence was seated as a juror in the trial of the son. The prosecution accepted him. Whether that was overconfidence, or exhaustion, or a calculation that objecting would look worse, the record does not say.
The trial ran through the whole of a Washington summer. The 2 printed volumes of the official transcript run to 1,383 pages. The witness count is worth getting right, because the popular figures are all over the place.
You will see 170 witnesses, over 200, over 300, and 62 days of trial. The last of those numbers comes from John Surratt himself, advertising his own lecture 3 years later, and he had reason to inflate.
What the printed index of the official record actually shows is roughly 300 witness appearances across the government's case. The defense case, the rebuttal, and the surrebuttal, with a number of witnesses appearing more than once, which puts the count of distinct human beings somewhere between 250 and 270. Either way, understand the scale. This was not a formality. The government threw everything it had at John Surratt for 2 months. They called Ulysses S. Grant. They called Colonel Henry Rathbone, who had been in the box at Ford's Theater and had been stabbed trying to stop Booth.
They called the Surgeon General of the United States. They called Frederick Seward, whose father Powell had tried to kill, and whose own skull Powell had fractured. They called the saloon keeper from next door to Ford's Theater. They called the detectives who had chased Booth into the Virginia barn.
And they called the 2 witnesses who had hanged his mother. John Lloyd testified for the government at the trial of John Surratt, and Louis Weichmann testified for the government at the trial of John Surratt, and his testimony runs from page 369 to page 437 of the first volume, which makes it the longest single piece of testimony in the entire record. Same witnesses, same story, different room.
Watch what happens to them in it. The defense of John Surratt was not that he was innocent of the conspiracy.
Joseph Bradley conceded the conspiracy. He stood up in an American courtroom and admitted that his client had joined a plot to kidnap the President of the United States and carry him to Richmond. He admitted the meetings. He admitted the carbines. And then he said the plot to kidnap had died in March, that his client had left Washington on the 3rd of April, and that on the night Abraham Lincoln was shot, John Surratt was 250 miles away in Elmira, New York, buying shirts. That is a real defense, and it was supported by real evidence. The government's theory required Surratt to be in Washington on the 14th of April. The defense produced a wall of witnesses to put him in Elmira. They produced the hotel registers, the Brainerd House, the Webster House at Canandaigua, the signature, John Harrison, in his own hand, on paper, dated. They produced Frank Atkinson and Joseph Carroll and Bernard Early and Edward Murphy. They produced William Failing and Frank Chamberlain and Henry Cook and Patrick McDonough and John O'Donnell and David Robinson. They produced August Bacchus and his wife Annie Bacchus, Elmira merchants and hotel men and ordinary townspeople, one after another, saying they had seen this man in their town that week. They produced Charles Boucher, the priest from St. Liboire, who came from Quebec to Washington to testify about hiding him. They produced General Edwin Lee, the Confederate agent who confirmed he had sent Surratt to Elmira on Confederate business. Against all of that, the government had one witness who put John Surratt in Washington on the day of the murder, a tailor named David Reed, who swore he had seen him on Pennsylvania Avenue on the 14th of April, wearing a distinctive coat. one man against 15. The government also leaned hard on two other things, and they were not evidence of the murder so much as evidence of consciousness of guilt. The first was flight. Pierrepont hammered it. An innocent man does not spend 18 months in 5 countries under 4 false names. He does not enlist in a foreign army under an alias. He does not jump off a wall in the dark. Innocent men come home and explain. The second was Dr. Macmillan, the surgeon from the Peruvian, who testified to what Surratt had told him at sea. Those are powerful arguments. They are also, both of them, arguments about a man's behavior after his mother had been arrested and his face had been printed on a reward poster next to John Wilkes Booth's, which is a set of circumstances that would make an innocent man run too.
The defense had one more line of attack, and it was the one that mattered, and it was the one that had been impossible in 1865.
They went after Louis Weichmann. In the military commission, Weichmann had given the testimony that framed the whole case against Mary Surratt. He was the one who described the comings and goings, who drove her to Surrattsville twice, who wrote the Nothi letter for her, who saw Booth hand her the package. He was the inside man. He had lived in that house. He had shared a bed with the defendant. And in 1865, nobody was permitted to ask him the only question that counted. Why are you testifying? In 1867, Joseph Bradley asked it. Louis Weichmann was arrested on the 17th of April, 1865, as a suspected conspirator in the murder of Abraham Lincoln. That is a fact, and it is not disputed by anyone. He had lived in the conspirators' boarding house. He had shared a bedroom and a bed with John Surratt. He had driven Mary Surratt to Surrattsville on both April trips. He had carried Booth's money to hire the buggy. He knew Surratt. He knew Powell as Mr. Payne the Baptist preacher. He knew Harold. He knew Booth by sight and by name. He worked in the office of the Commissary General of Prisoners at the War Department, where the records of Confederate prisoners of war were kept, which is precisely the information a kidnapping plot designed to force a prisoner exchange would want. John Surratt said, from a public stage in 1870, that Weichmann had been a party to the plan to abduct the president. He was arrested as a conspirator. 6 weeks later, he was the government's star witness. He was never charged with anything. Now, in the military commission, there was no mechanism to explore that. There was no rigorous cross-examination, no defense investigator, no subpoena power worth the name, and no ability to call witnesses to impeach a government witness's motive. Frederick Aiken did what he could. It was not much, and it was not enough. In the criminal court of the District of Columbia in 1867, Joseph Bradley had all of it, and he put on 2 witnesses whose testimony is in the official printed record, and whose testimony the tribunal that hanged Mary Surratt never heard. The first was Louis Carland, a costumer at Ford's Theater. Carland testified that Louis Weichmann had told him, personally, that if he had been allowed to testify as he wanted, and had not been threatened with prosecution as a conspirator, things would have been different with Mrs. Surratt. Things would have been different with Mrs. Surratt. The second was James Gifford, the stage carpenter at Ford's Theater. Gifford testified that he had heard an officer tell Weichmann that he would be hanged unless he said more than he had already said. And James Ford, of the theater family, reported that a deputy keeper at the prison had described Weichmann as the most frightened witness he ever saw. I have to be careful with you here, and I am going to be. That is not proof that Louis Weichmann lied. It is testimony from 3 men connected to Ford's Theater, an institution with its own grievances against the government, about conversations with no independent corroboration. Carland and Gifford were defense witnesses, and they were cross-examined hard, and Louis Weichmann never took a word of it back, not once in 37 years. He was hounded for the rest of his life as the man who hanged Mary Surratt. He moved. He lost jobs over it. He wrote a book defending himself, which was not published until 1975. And on the 5th of June, 1902, in Anderson, Indiana, dying and no longer able to speak, Louis Weichmann took a pen and wrote out a statement that he wished the people of this country to understand that in the great trial and while on the witness stand, he told the truth and nothing but the truth. A man writing that with his last strength is not nothing. It is worth as much as anything, Carland said. But now look at what the 2 proceedings did with the same problem, because that is the entire argument of this documentary, and here it is in miniature. In 1865, a military commission heard Louis Weichmann's account, could not test his motive, was given no evidence about how his statement was obtained, and voted to hang the woman he testified against. In 1867, a civilian jury heard Louis Weichmann's account, and then heard sworn testimony that he had been threatened with the gallows to get it, and heard him cross-examined for days by a lawyer with the time and the tools to do it properly. And that jury would not convict. Same conspiracy, same evidence, 1 rope, 1 jury. There is one more thing, and it is the coldest fact in this documentary. John Lloyd testified for the government in 1867 as well. The same drunk man, the same shooting irons, the same afternoon in the same tavern yard. In 1865, that testimony was sufficient to hang a woman. In 1867, put in front of 12 ordinary citizens who were allowed to weigh it properly, it was not sufficient to convict her son of anything at all. On the 2nd of July, 1867, 3 weeks into the trial, the court took a recess until the following morning, and as Judge George Fisher came down from the bench, Joseph Bradley Sr. walked up to him. What happened in the next 90 seconds is disputed in every particular, and both versions are in the United States reports, because this became a Supreme Court case. Fisher's version, written in his own order. Immediately after the court had taken a recess until the following morning, as the presiding justice was descending from the bench, Joseph H. Bradley, Esquire, accosted him in a rude and insulting manner, charging the judge with having offered him a series of insults from the bench from the commencement of the trial. The judge disclaimed any intention of passing any insult whatever, and assured Mr. Bradley that he entertained for him no other feelings than those of respect. Mr. Bradley, so far from accepting this explanation or disclaimer, threatened the judge with personal chastisement. Bradley's version, flatly contradicting it, was that the encounter happened after the judge had left the courtroom and the building and returned, that he never threatened anybody, and that on the contrary, the judge was from the opening of the interview violent, abusive, threatening, and quarrelsome. Fisher wrote his order. It ends like this: no court can administer justice or live if its judges are to be threatened with personal chastisement on all occasions, whenever the irascibility of counsel may be excited by imaginary insult. The offense of Mr. Bradley is one which even his years will not palliate. It cannot be overlooked or go unpunished. It is, therefore, ordered that his name be stricken from the roll of attorneys practicing in this court. Struck from the roll. Disbarred. The end of a career at that bar.
And now the detail that tells you what kind of man Fisher was, and what kind of trial this was.
He did not enter the order on the 2nd of July. He wrote it, and he sat on it, and he kept sitting on it, while Joseph Bradley stood up in his courtroom day after day for 5.5 more weeks, and defended a man on trial for his life. He entered it on the 10th of August, 1867. The same day the jury was discharged, within hours. He waited until the case was over, and then he destroyed the defense lawyer. That is not a rumor. That sequence is recited in the Supreme Court's own statement of facts. There is more. According to contemporary newspaper reports, after the court adjourned that day, Joseph Bradley followed Judge Fisher out of the building and handed him a note aboard a streetcar, and the note was understood to be a challenge to a duel. Police intervened. There was public speculation that Bradley might be indicted for it. I will flag that honestly. The duel challenge is in the press, not in the legal record. The Supreme Court's account of the case does not mention it. Bradley sued Fisher for damages. He lost, and in losing he made law that governs the United States to this day. Bradley against Fisher, decided in 1871, is the foundational American authority for absolute judicial immunity. The Supreme Court held that a judge of a court of general jurisdiction cannot be sued in a civil action for his judicial acts, even if those acts are alleged to have been done maliciously or corruptly. Sit with the shape of that. The lawyer for the last Lincoln conspirator got himself permanently disbarred by the judge trying the case, sued that judge, and lost. And the case he lost is the reason American judges still cannot be sued for what they do on the bench. But that is the epilogue. On the 7th of August, 1867, the case went to the jury. 12 men went into a room in Washington on Wednesday, the 7th of August, 1867, to decide whether John Harrison Surratt, Jr. would hang for the murder of Abraham Lincoln. They were in there for approximately 70 hours. 3 days, through Wednesday night, through all of Thursday, through Thursday night, through all of Friday, through Friday night, into Saturday. In a Washington August, in a closed room, in 1867, with no air conditioning and no relief. They had been sequestered for 2 months by then. On the 4th of July, in the middle of the trial, they had been taken out to Montgomery Blair's estate at Silver Spring for the holiday, and George Borer, the juror who had said he could not have convicted Mrs. Surratt, was one of 3 men chosen to arrange the festivities and to read the Declaration of Independence aloud to his fellow jurors. That is a real thing that happened. 11 men sat on a lawn in Maryland and listened to a 12th read out the sentence about governments deriving their just powers from the consent of the governed. And then they went back to town and spent 5 more weeks deciding whether to hang the son of a woman the government had killed without a jury. On Saturday, the 10th of August, they sent word that they were finished. The end of it is recorded minute by minute in the contemporary press. At 1 o'clock, John Surratt was brought into the courtroom. At 5 minutes past 1, Judge Fisher resumed his seat. At 8 minutes past 1, the jury was brought in. The foreman, William Todd, stood up. We have not been able to agree. Their written note said they stood precisely now as they first balloted upon entering the room, nearly equally divided, and that they were firmly convinced that they could not possibly make a verdict. They asked to be discharged, in view of the fact that the health of several of our members is becoming seriously impaired. Judge Fisher said that if there was any possibility of the jury agreeing, he would not object to keeping them for a reasonable time, but that as he was informed they could not possibly agree, he would discharge them. At 1:10 on Saturday the 10th of August, 1867, the jury in the trial of John H. Surratt for the murder of Abraham Lincoln was discharged. 2 minutes from the jury entering the room to the end of the case.
Now the number.
The vote was 8 for acquittal and 4 for conviction. And the contemporary press did something better than report the split. It named the 4. The Orangeburg News, reporting on the 17th of August, 1867, identified the 4 jurors who held out for conviction as Todd, Snyder, McLean, and Barr. That is the foreman, William Todd, along with Christian Schneider, William McLean, and Russell Barr, 8 of the 12 men who sat through 2 months of evidence, who heard 300 witness appearances, who heard John Lloyd and Louis Weichmann and Dr. McMillan, and the tailor who swore he saw him on Pennsylvania Avenue, and who knew perfectly well that the defendant had admitted joining a plot to kidnap the President of the United States, voted to let John Surratt go. There is a small, honest tension in the record, and I will give it to you. The jury's own note said they were nearly equally divided, which does not describe 8-4. Either the note was a face-saving formula, or the split had moved during those 70 hours. Nobody knows. What nobody disputes is the direction. A clear majority of that jury would not convict him.
Zine, understand precisely what that means, because it is the payoff of this entire documentary, and I do not want it to slide past.
It does not mean they thought he was innocent.
It means that 12 ordinary citizens of Washington, given the full evidence, given a real defense, given the presumption of innocence and the requirement of proof beyond a reasonable doubt, and the rule that all 12 must agree before a man can be hanged, could not reach the standard.
That is the standard Mary Surratt never got. 6 votes out of 9, from officers appointed by the man who ordered the court into existence, was enough to kill her. 12 votes out of 12, from citizens who were allowed to doubt, was not enough to kill her son. Same conspiracy, same evidence. 1 rope, 1 jury. And the difference between those 2 proceedings is not a difference in the facts of the case. Every material fact was the same. The difference is entirely, exactly, and only the procedure. That is what the phrase due process of law means. It is not decoration. It is not a formality lawyers insist on to slow things down. It is the difference between a woman who has been dead for 2 years and a man who walked out of a courthouse in August of 1867 and lived until 1916.
There is a part of this story that almost never gets told alongside the rest of it, and when you put it in place, it stops being a story about one woman's bad luck and becomes something much harder to look at. Watch what the United States government did with the other people it convicted in that same courtroom in 1865. 4 were sentenced to hang and were hanged on the 7th of July. 4 were not. Samuel Arnold, Michael O'Laughlin, and Dr. Samuel Mudd got life. Edmund Spangler, the stagehand at Ford's Theater, got 6 years. And instead of a federal penitentiary, they were shipped to Fort Jefferson in the Dry Tortugas, 70 miles west of Key West, a brick hexagon sitting alone on a coral shoal in the Gulf of Mexico. It was chosen because escape from it was effectively impossible, and because nobody who was sent there was expected to be heard from again.
In the summer of 1867, yellow fever came to Fort Jefferson. Spangler was writing letters home through it. 2 or 3 dying every day, he wrote. Later that month he counted it up. 280 cases and 30 dead so far. He spent that autumn making coffins, day and night, which was what a theater carpenter turned out to be useful for. The post-surgeon caught the fever and went down. There was no doctor left on the island. And Samuel Mudd, who was serving a life sentence for treating John Wilkes Booth's broken leg, volunteered. He took over the medical care of the garrison that had been holding him prisoner. Spangler's own letter says it flatly. There is no doctor here but Dr. Mudd, and he volunteered his services, and he was very successful. On the 23rd of September, 1867, at 7 in the evening, Michael O'Laughlin died of yellow fever on that island. Spangler wrote it down the next morning. Poor Michael O'Laughlin, my friend and roommate, died at 7 o'clock yesterday of yellow fever. When the epidemic was over, the soldiers of the garrison, the men who had been guarding him, signed a petition asking the President of the United States to release Dr. Samuel Mudd. And Andrew Johnson did. On the 8th of February, 1869, in the last weeks of his presidency, Andrew Johnson pardoned Samuel Mudd. 3 weeks later, on the 1st of March, 1869, 3 days before he left office, he pardoned Samuel Arnold and Edmund Spangler. Every single person the military commission convicted and did not kill was eventually pardoned by the man who had approved the sentences. Read that again slowly. The government reconsidered for everyone it had not already executed. And now here is the coincidence in the record that I did not expect to find and could not quite believe when I checked the dates. Anna Surratt petitioned Andrew Johnson for her mother's body on the 3rd of February, 1869. Johnson granted it. The remains were released to the family on the 8th of February, 1869. The 8th of February, 1869, is the day he pardoned Samuel Mudd. On one day, in the last month of a failed presidency, Andrew Johnson signed a paper that let a convicted conspirator walk off a prison island alive, and signed another that let a daughter go and dig her mother out of a trench beside a scaffold. That is not a metaphor I am imposing on the material. Those are 2 dated documents with the same date on them. Now I want to close the evidentiary question honestly, because I promised you at the start that I would not put my thumb on the scale, and here is where I keep that promise. Was Mary Surratt guilty? There is no dispute at all about the following. Booth and the conspirators met repeatedly in her house. She drove to Surrattsville on the 11th and the 14th of April. On the 14th, she carried a package from Booth containing his field glasses and left it for John Lloyd. Booth came to see her privately at H Street hours before he shot the president. The weapons were in fact retrieved from her tavern that night, and she stood in her own hallway and swore before God that she did not know Louis Powell, and that was false. What is disputed is whether she knew the plan had changed from kidnapping to murder. The strongest modern case that she did is Kate Clifford Larson's In the Assassin's Accomplice, published in 2008. Larson's argument is partly evidentiary and partly historiographical, and the second half is the more interesting one. She argues that a century of writers exculpated Mary Surratt on the basis of assumptions about female passivity, that they could not imagine a middle-aged Catholic mother as an author of anything, and that the record shows a capable, intelligent, politically committed woman making her own decisions. In Larson's words, she was a really smart woman who made her own independent decision, and not all women do things because they're in love with some man. They have their own agency. Michael Kaufman and Edward Steers broadly agree that the Surratt operation was functionally integral to Booth's plan. The case, on the other side, runs back to 1895, and David Miller DeWitt's book, and the title is worth noticing because it is more precise than the argument people make from it. He called it the judicial murder of Mary E. Surratt. Judicial murder. DeWitt notably declined to declare her innocent. His argument was about the tribunal, not the woman. That distinction is the one this documentary has been making for 2 hours, and it is the one that keeps getting flattened. Elizabeth Trindall, writing in 1996, went further and argued she was railroaded, that Weichmann and Lloyd lied or misled the commission, and that a civilian court would never have convicted her. Lori Verge, who ran the Surratt House Museum for decades and knew this record better than almost anyone alive, observed that only in the case of Dr. Mudd is there as much controversy over guilt or innocence, and where the field actually sits today is that most serious historians decline to make a conclusive claim either way. So I am not going to make one either. Here is what I will say, and it is the only thing this evidence will carry. Mary Surratt aided the conspirators. That is established. Whether she knew what she was aiding on the 14th of April, 1865, is genuinely unknown and will stay unknown, because the one proceeding that existed to find out was structured so that it could not. Same conspiracy, same evidence, one rope, one jury. The government did not give up on the 10th of August. John Surratt was taken back to jail, and Edward Carrington went to work on a second indictment. The problem was that the government's fallback charges, the conspiracy counts, and the offenses connected with the rebellion carried a 2-year statute of limitations, and by 1868, that period had run out several times over. Murder had no limitation, but the murder charge had just been put to a jury and produced nothing, and going back for a second bite on the same evidence in front of the same city was not an attractive proposition. In June of 1868, the court held that the statute of limitations had expired on everything except the murder count, and John Surratt was released on bail. The case was formally abandoned that autumn. A nolle prosequi was entered, and the standard date given for it is the 6th of November, 1868, though some accounts place the dismissal in June. I flag that because the underlying docket has not been fully published, and I would rather tell you the record is uncertain than give you a clean date I cannot stand behind. He was 24 years old. He was free. He was never tried again.
And then he did something that is difficult to defend on any level.
He went on the lecture circuit. On Tuesday, the 6th of December, 1870, at the Montgomery County Courthouse in Rockville, Maryland, John Surratt stood up in front of a paying audience and talked for about 75 minutes about his role in the plot to kidnap Abraham Lincoln. The text survives because the newspapers took it down. He described meeting Booth. "It is useless for you, Mr. Booth, to seek any information from me at all. I know who you are, and what are your intentions." He described Booth's proposal. It is to kidnap President Lincoln and carry him off to Richmond. He described his own answer. After 2 days' reflection, I told him I was willing to try it. He described the plan in operational detail: the ambush on the road to the soldiers' home, the run for southern Maryland by way of Benning's Bridge, and his confidence about it. We felt confident that all the cavalry in the city could never overhaul us. He described the failed attempt in March, and then he made the denial that he built the rest of his life on. Such a thing as the assassination of Mr. Lincoln I never heard spoken of by any of the party. Never. He also used the stage to name Louis Weichmann. I proclaim it here and before the world that Louis J. Weichmann was a party to the plan to abduct President Lincoln. I have to put a frame around all of that for you. This is a self-exculpatory speech by a man selling tickets, delivered 5 years after the events, and the surviving text comes from newspaper transcriptions. It is authentic evidence of what John Surratt said. It is not evidence of what happened. But notice what he did and did not admit, because he was not stupid, and the distinctions are lawyerly. He admitted the kidnapping conspiracy completely and cheerfully. He denied the murder absolutely. Those were exactly the two positions that had already been tested in court, and he knew he could no longer be prosecuted for either. He announced a second lecture. Washington, District of Columbia, Friday the 30th of December, 1870. Oddfellows Hall on 7th Street above D. The broadside advertising it survives in the Huntington Library, and it is a remarkable object, because you can hear the defiance in the typography. J.H. Surratt will most positively deliver his lecture. In Washington, on the above date, all reports to the contrary notwithstanding, he promised a full and truthful account of his thrilling adventures during the rebellion, his introduction to J. Wilkes Booth, and the plan arranged to kidnap, not murder, President Lincoln, and his trial, continuing 62 days, and honorable acquittal. It was not an acquittal. A hung jury is not an acquittal. He knew that too, and he printed it anyway. The Washington lecture never happened. The usual explanation is that public outrage forced its cancellation, and there is clearly something to that, because the phrase, "all reports to the contrary notwithstanding," tells you there was already pressure and rumor before the handbills went up. But the specific reason the rescheduled date collapsed appears to be more banal. He was arrested in Richmond the day before, on charges arising out of a failed tobacco venture. A reviewer in New York, writing about the tour, called it
the most flagrantly and deliberately indecent method of making money which has ever occurred to the depraved human mind.
The tour died. And that, more or less, is where John Surratt stops being a public figure. What John Surratt did with the next 45 years is the most ordinary thing in this entire story, and that is exactly why it is unbearable. He taught school. He was at the Rockville Female Academy in Montgomery County from 1870, and a former pupil named Conrad Mott remembered him decades later as a good teacher, a good man, affectionately remembered by all the people who took their lessons under his guidance. In 1873, he became principal of St. Joseph's at Emmitsburg, in Frederick County. He resigned by January of 1874. He was tired of the country. In a letter written on the 26th of April, 1873, he put it plainly.
My greatest desire, Father Jolivet, is to leave this abominable country and go to Europe there to spend the balance of my days in peace and quiet. He never went. In 1872, he married Mary Victorine Hunter, who was a second cousin of Francis Scott Key.
They were married for 43 years and had a large family.
The sources disagree about the exact number of children, 7 in most accounts and 10 in others, so I will not give you a figure I cannot stand behind. He was the only one of Mary Surratt's 3 children who left descendants. In 1874, he took a job with the Baltimore Steam Packet Company, the Old Bay Line, which ran overnight steamers down the Chesapeake between Baltimore and Norfolk. He started as a freight auditor. He was good at it. He became general freight agent and eventually treasurer of the company. He worked there for about 40 years and retired shortly before the First World War. He died at his home in Baltimore on the 21st of April, 1916, of pneumonia, aged 72, with his wife and several of his grown children in the room. He outlived every other person in this story by decades. John Wilkes Booth died at 26 in a burning tobacco barn 12 days after the assassination. Lewis Powell was 21 on the scaffold. Andrew Johnson died in 1875. Joseph Holt died in 1894, still publishing pamphlets defending himself over the Clemency Petition. Judge Fisher died in 1899. Joseph Bradley died in 1887, disbarred. John Lloyd, the man whose testimony about the shooting irons hanged Mary Surratt, went back to Washington in October of 1865 and worked the rest of his life as a bricklayer and a building contractor. In December of 1892, a scaffold collapsed on a job he was helping with, and he died of his injuries on the 18th of December, 1892, aged 56. When Lloyd died, the New York Sun wrote about the woman he had testified against. She was a victim of circumstances. Her association with the real conspirators was the cause of her conviction. That was the verdict of the newspapers, 27 years after the fact, on the strength of nothing new at all. Anna Surratt got her mother's body back in February of 1869. She married a government chemist named William Tonry in June of that year at St. Patrick's Church in Washington. Tonry was dismissed from his federal post within days of the wedding, which everyone at the time and since has read as punishment for whom he had married. He rebuilt. He opened his own laboratory in Baltimore and became a professor of chemistry and a sought-after expert witness. They had 5 children and 4 survived. A reporter who saw Anna in 1880 described her as rather tall, with a thin, small, pleasant face, plainly marked with lines of severe suffering. She was afraid, in specific and recurring episodes, for the rest of her life. She died on the 24th of October, 1904, aged 61. The boarding house at 541 H Street was mortgaged to pay the lawyers and sold on the 13th of November, 1867, 3 months after John Surratt's jury went home. It kept running as a boarding house. It acquired a reputation for being haunted, which the New York Times felt obliged to address in print in 1866. The ground floor was converted to commercial use in the 1920s. It was raided for illegal liquor in 1928. It stands today at 604 H Street Northwest, in the middle of Washington's Chinatown, and it is a Chinese restaurant, and it has been on the National Register of Historic Places since the 11th of August, 2009. People eat lunch in Mary Surratt's parlor every day without knowing it. The tavern at Surrattsville was sold in 1869 for $3,500 with 6 acres. It passed through 5 owners. The state of Maryland bought it in 1965, and it opened as a museum
in 1976. You can stand in the room where the carbines were hidden in the ceiling. Mary Surratt is buried at Mount Olivet Cemetery in Washington, District of Columbia. Anna is beside her. Her son Isaac, who came back from the Confederate cavalry and never married, is beside them. John M. Lloyd is buried in the same cemetery, less than 200 feet away. Her original headstone said only, Mrs. Surratt. It was defaced so often that it had to be replaced in 1968. John Harrison Surratt, Jr. is buried in New Cathedral Cemetery in Baltimore, Maryland, about 40 miles from his mother. They are not together. Now, let me close by returning the two things this documentary opened with, because I want to leave you holding them and not holding a moral. The first is a number, 81 days. That is how long the United States government took to arrest a 52-year-old widow, try her without a jury, deny her an appeal, refuse the clemency her own judges requested, override a federal judge's writ of habeas corpus at 10 in the morning, and hang her by 1:30 that afternoon. The second is a sentence, spoken by a man named William Todd in a Washington courtroom at 1:08 on the 10th of August, 1867, about her son, who had done more than she had and admitted it. We have not been able to agree. That is the whole distance. That is what the shield of the Constitution is, in practice, when it is actually held over somebody. It is not an acquittal. It is not vindication. It is not even a finding that the accused is innocent. It is 12 tired men in an August room in Washington saying that they were not sure enough to kill a person and being allowed to say it and having that be the end of the matter. Mary Surratt was never given a room where 12 people were allowed to be unsure. And the last word here belongs to the man who tied the ropes, because Christian Rath went out into that yard on the evening of the 6th of July, 1865, with 4 lengths of rope in his hands and a regulation in his head that said 7 turns of the knot, and he could not make himself do it. He said so, plainly, 46 years later, and he never stopped being haunted by it. I put 7 knots in each one except one, and I only put 5 in that, for I fully expected that Mrs. Surratt would never hang. The executioner did not believe it would happen. It happened anyway.